We're about to talk about allegedly one of the most horrific cases of child abuse we have seen. These two people are accused of beating and starving their adopted son, a 10-year-old boy. We will go over what is alleged in court documents. The details are that of nightmares, what this young boy had to endure until he lost his life. We're on the case presented by Law&Crime. I'm Chris Stewart. It is not easy to talk about cases like the one that we're talking about today, and it is hard to believe that if what is alleged is true, that the suspects in this case would exist on this planet. But here they are being led in front of media cameras in San Antonio, Texas. This video is per KENS TV. Their names, Jonathan and Christina Miranda, both are now charged with capital murder. This is a picture of their adopted son. His name was Michael. He was 10 years old. You can see that big smile that he had on his face. His adoptive mom, now facing charges in this case, told police that Michael was adopted after he was allegedly the victim of abuse, neglect, and sexual abuse. Now, we don't know how much truth there is to that based on what that woman and her husband are now accused of. But it is clear this boy certainly deserved better in his young life. This is the home that police were called to on September 24th at 9:22 p.m. I will warn you once again, it's not easy to talk about what they say they found inside this home. And just wait until you hear what the suspect's attorney is saying in their defense. They say there is more to this story. Now, inside the home, police say they found young Michael unresponsive. They tried to save him, but he passed away. Now, here are the injuries that police say that young boy had. He seemed to be starving, they say, emaciated and malnourished. He had abrasions on his face, legs, and feet. There appeared to be bruising and trauma over his back in various stages of healing. Court documents also say the boy was wearing a diaper. Remember, he's 10 years old. And they say when they removed that diaper, he had sores on his behind. He was also allegedly suffering from what's called severe rectal prolapse. That means that his large intestine was bulging out of his behind. The medical examiner also found a possible internal traumatic injury to Michael's neck. As police searched the house, Michael's adoptive parents were taken to the police station for questioning. His father, Jonathan, immediately requested a lawyer. Now, as far as what Christina, the mom, said, you need to first understand what police say they found in this home beyond the injuries on young Michael, allegedly. Specifically, they say in the laundry room, police found dried feces. They also found broken drywall, which they believe means that there was some kind of violence or struggle that took place there. There was also a pad that police say was designed for pets that was positioned in a way where police believed that a human had to use it as a toilet. There were also charts on the wall with writings that appeared to show that Michael's parents had some sort of like a checklist marking different tasks that he did. Christina, when she was in custody, allegedly said that Michael wasn't feeling well, so they kept him in that room for a couple of days to monitor him. Police noted in their report that based on the evidence, like the dried fecal matter, for example, Christina was allegedly lying. When officers asked her how long Michael was in that room, just like her husband, Christina allegedly then lawyered up. Now, police say they interviewed other children living in the home. The kids allegedly said that Michael was physically beaten every single day. They said the parents allegedly used a wooden paddle or a rubber paddle with a metal inside to it. They also would allegedly pick Michael up by his feet and then throw him to the floor until he stopped moving or whining. Now, the children also said that Michael would be forced to stand against the wall for extended periods of time, and he was hit in the torso with a paddle. Police also note that when the children gave what they believe are corroborated statements about what was going on to Michael in the house, they would ask that their parents not be told what they were saying. And as far as Christina allegedly saying that Michael was held in the room for a couple of days, police actually believe that boy was held in that room for roughly a year. Michael also had fractured ribs, several that were in various stages of healing, according to the medical examiner. Both his femurs were damaged. His arm was dislocated. There were so many injuries, but the preliminary cause of death, they say, was related to a lacerated lower intestine, according to the medical examiner. They believe that had to be caused by a punch, a kick, or the use of an object hitting the boy. Before I get back to this episode of On the Case, I need to take a moment and pause and talk about our partners at Morgan & Morgan, America's largest injury law firm. They have more than 1,000 attorneys and they win a lot. They've recovered over $25 billion from more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being offered only $500,000. Now, even if you don't think your case is worth millions of dollars, why not fight for what you deserve? Morgan & Morgan makes it so easy to start a claim. You can do it with 8 clicks on your phone. So if you've been injured and you need to start a claim, go to www.forthepeople.com/OTC. You can also scan this QR code on your screen or click the link below. Both Jonathan and Christina Miranda are now facing charges of capital murder. As horrific as those allegations are to hear, they're certainly difficult to say. Is there more to this story? Now, this is a picture of the couple from Facebook. KVUE-TV says that Jonathan Miranda hired a defense attorney after Michael died, but this attorney is specifically working a case involving CPS and the investigation into what was going on in the home. This attorney is not involved in the capital murder case that Jonathan Miranda is facing. But that attorney told that TV station, KVUE-TV, that Michael actually was suffering from a pre-existing physical and behavioral condition, and it was related to a prior brain tumor. He also says the boy would bang his head against the wall and would even be aggressive towards people. The attorney says that a total of 6 children lived in the house and they were all homeschooled, but Michael did see medical professionals not long before he died. Joining me now to talk more about this story from Texas is trial attorney and former prosecutor Bridget Williams. It's always great to have you on Law and Crime. I know this story is certainly not easy to talk about. It was really hard to read through the arrest warrant for these parents, the probable cause that police say that they have. From the prosecution standpoint, what would stand out to you if you were prosecuting this case just based off what police say they found in the house?
So many things stand out. I think you stated it perfectly. It's very difficult to just even read through the information that happened to this child, because that's exactly a child. Some of the things that would stand out immediately was past trauma. So it showed that he had just like a history of lacerations on his body, things that were healing in his body, previous wounds, previous injuries that were healing. And so that's something that shows an ongoing either sense of abuse, some type of injury that was ongoing before and that he's healing from. And so that means that this wasn't the first time that something happened to him, and he was experiencing that over and over again. And that would be something as a prosecutor that I would be bringing up in a trial setting.
Yeah, because it's always hard after reading an arrest warrant like that, an affidavit like that, to say, well, there's 2 sides to every story. But this defense attorney for Jonathan Miranda, who's not handling the capital murder charge, but I guess the investigation into CPS, he's representing him, he reportedly said that the abuse was going on before this boy was adopted by the Mirandas, that the boy had been the victim of abuse of many types in the past, that he apparently had a brain tumor at one point, and that led to him having a condition. I guess, how could that play out in court in figuring out the timeline of what exactly happened to this boy?
Yeah, I would say the defense counsel is going to be bringing in quite a few experts. They're going to be hiring multiple experts that say, well, the lacerations and various injuries that he had, may have been caused from years and years ago. That could be the case. We don't know. But that would be something that an expert would have to testify to and give an affidavit that says, okay, based off of my training and experience, this happened so long ago, and this was something that, and the current injuries may have been self-inflicted, right? So an expert would have to testify to that. But if there's no expert that says that these wounds are self-inflicted, that he died from, right, then that's not something that would really go pretty far. I would say that defense counsel will be having multiple expert witnesses, but the prosecution will too, that will say the opposite, right? They'll say the opposite, that these injuries were something that was caused from an adult. There was information in the reports that this child was malnourished, and that didn't receive, was very fragile and frail. And that's something that is caused from parents, right? The child doesn't have the opportunity to go and get food. If he doesn't have a car, he doesn't have resources to go do that. That's from the parents. So there's multiple things I would say that defense counsel will be bringing experts, but the prosecution will be doing just the same, but for their side.
Because I feel like you can always find, and we've seen in a lot of trials, you can find an expert that'll support your theory. But what goes into determining whether or not that expert has the credibility to actually go on the stand? Because I'm sure the defense will be able to find someone to say, listen, these wounds are consistent from what I'm seeing with the boy doing it to himself because he had this sort of condition. What actually goes into determining whether that person can actually testify in front of a jury?
So, like you said, any person can find something or find a person that can say, yes, they agree with us, or find an expert that will agree to those things. But then there's going to be a hearing before a judge, and the judge makes a determination if the expert has the qualifications, the training, experience, knowledge, in order for them to actually be able to testify before a jury. And so it's up to the court. The court that makes the determination on if that witness's testimony is able to be provided in front of a jury or not.
And then it seems like that the children who were in the house, I guess there was a total of 6 children, including Michael, living in this home, and they witnessed, they say, this alleged abuse that took place. I mean, some pretty horrifying things. You think of these young kids and what they say that they witnessed in the house. How, as a prosecutor, and we don't know the ages of these children, we certainly know they're under 18 years old, but I don't know how young they are, but how would they factor into a trial and that testimony in painting this picture that they want to in saying that the Mirandas are responsible for this?
Yeah, that's a tough one. I would say it depends a lot on their ages. And if I was a prosecutor, I would have like maybe someone, an investigator, speaking with the children, being able to kind of just get their stories out. But you don't want to put a child on the stand if, one, they're not ready. That's a lot for a child to endure, and to go and talk about the things that they witnessed in front of a jury. That is a lot. That's a lot of pressure for a child to do. And so, and sometimes if they're able to get their point across without that, then I would do that if I was a prosecutor. I would try to do it without, try to put the children through that, because it's a mental issue for them as well. Like, that's going to be just kind of mental gymnastics is what I call it, just kind of going back through that again. So if they can do it without it, then I would proceed further. Will it help their case? 110%, because they have firsthand eye witnessing about what was going on in the household. They are the people who were there experiencing it right along with the boy who died. So they would be able to testify to that. But it just depends. I guess you kind of just see the maturity of each child, where they are mentally, and just kind of make a decision from there.
Because I also think in the court documents, each child had said, please don't tell my parents that I'm telling you this. And so to think that they would have to testify in the same room with their parents sitting at the defense table, it's just, you think of the pressure there. But I also think for a defense attorney, and this is why defense attorneys get paid pretty well, is if a child goes on the stand and you have to be the person to then challenge their credibility in this room in front of the jury. Yeah. How does a good defense attorney go about doing that in a way where they wouldn't alienate jurors from thinking that this guy's just a jerk, and being sympathetic to this person who's saying that your client, committed some pretty horrible crimes here?
That is a tough one. I think, again, that's going to be a case-by-case basis. After a defense attorney is able to see what are the questions that prosecutor would ask on their just first line of questioning, right? So what are we asking just on the direct? And then after that, they can be able to assess to see how can they really come back at it. It's going to be just a case-by-case basis. I don't think there's a general rule for that because, again, you're dealing with a child, right? And so you don't want to, like you just said, come off as combative. You don't want to come off as aggressive. You don't want to come across as saying, oh, you are, lying to us, right? It's a child. So they just have to really just really be paying attention to the questions that the prosecutor is asking, and then be able to kind of just circumvent that in their redirect.
Both parents are facing a charge of capital murder. I noticed in the court documents that they were separated, which is pretty standard, and the dad ends up asking for his lawyer. The mom ends up making a statement a bit that saying that the boy was in the room for only a couple of days. Police say that's not true, but then she asks for a lawyer. How does it work in Texas if they would be tried together or separately?
I think something like this may be tried separately, depending upon what all is necessary. So the court will make the determination on if it's something that they should be tried together or tried separately. If it's a good resource, a good timing of the court's resources, because if it's all the same witnesses, if it's all of the same discovery evidence that's going to be used for both of the defendants, then the judge may decide, well, yes, we'll move forward with this together. And so it just depends on if it's a good use of the court's resources and timing to have them tried together or separately.
If you were defending, let's say, the mom, Christina Miranda, would you want this tried separately, or would this be something you'd want to be a unified front with your husband?
Yeah, well, first, I don't try cases with children involved, but if that
Sure.
was the case,
Yeah.
I would say that I would probably want to be tried, I would want to be tried separately. Because if this, let's say, it's kind of like a pointing the fingers, right? We can say, well, it was him who did something. I didn't do anything at all. Now we're kind of being able to point fingers at the other person, and just kind of have that conversation a little more, and have it just better told that way. I would request, if I was her attorney, that it be tried separately.
And then I think where they're both now facing this very serious charge of capital murder, but there's still, it seems like there's a lot of moving pieces in terms of what is an incredibly tragic life that this child had for 10 years, because whatever his family situation was before the Mirandas, they say it was a very tough, abusive upbringing he had to that point. We don't know how long he was with the Mirandas, but allegedly the abuse continued, perhaps even worse than before. He had a brain tumor at one point, the lawyer says. What type of work is done now that an arrest has been made? And how long does it take to try and piece together the timeline for both the prosecution and defense to actually figure out what this child's life was like to the point where he died?
That's such a great question. Putting together a timeline for something like that, it's going to be pretty labor intensive, I would say, because you now have to get in communication with, CPS and what their understanding was with his situation prior to them living with the Mirandas, getting contact with doctors' offices, medical providers that may have seen him prior to him living with the Mirandas as well. There's just going to be so many individuals that they need to get in communication with, and that's on the defense and the prosecution side. And that's going to be all things that are necessary to prepare for a trial. I think even necessary to prepare for just negotiations. If they decide they want to try to work out something pre-trial, that's going to be vital information in order for them to be able to have just a discussion about mitigating the punishment ranges here. And so all of those things are going to just take some time. But that's the reason why statute of limitations on a capital murder case is not existent. There is none. They have some time to put that together. So they may not even have an actual court date for a little while.
And just on the charge, when it's capital murder, and I know charges, what murder is, murder one, murder two, in different states, it can mean different things. But in Texas, what does capital murder mean?
That person can be facing the death penalty. And so we have quite a few cases in which a person can be facing capital murder. And so the killing of a child is one of those. And so that meets the elements necessary in order for a person to be facing the death penalty.
Do you find, and maybe not in cases that you've been part of on the prosecutorial side, but just generally speaking in Texas, that having that capital murder charge and the potential of the death penalty for a defendant, that can be an effective bargaining tool for the prosecution when it comes to trying to determine maybe life without parole instead of having these kids who might have to testify at a trial, which they may not want to do. The fact that the death penalty is possible in Texas, do you find that to be an effective negotiating tool for prosecutors?
110%. Because the thing is, if you're a defense counsel, sometimes it's our job just to try to reduce the sentencing, right? I think sometimes people think that defense counsel's job is always to try to get somebody off, right? That's not always the job. Sometimes the job is just trying to reduce it and make sure that the person does not get the death penalty. And if they don't get the death penalty, sometimes that's a win. And so in a situation like this, the prosecution knows that. They know that if, there's communication with the defense counsel, if there's an overwhelming amount of evidence that is showing that this person is checking all the elements of the boxes for capital murder, and we have now bargaining power to say, well, instead of offering this person the death penalty, we will offer life without parole, like you just stated, or 100 years, whatever it is, right? They have that opportunity now. They have a leeway over that now. So that would be something that defense counsel can say, well, you're not going to the death penalty, but now you have to spend the rest of your life in prison.
And knowing that they're both arrested now and facing these serious charges and being held on pretty significant bonds, yet there could be a lot of work to be done to figure out the timeline and the history of this boy's life. I guess typically, how long does it take from arrest to a potential conviction and trial in a case like this?
Okay, that one's going to be just a case-by-case basis, because like you just said, it takes so much to get all the information prepared for by the police department to present that case to the DA's office, and the DA's office intake team to decide they're going to accept it, then move forward. So that could take, I've seen it take years, I've seen it take months, but the statute of limitations there is none on a capital murder case. So it could be 5 years before they actually have an actual case. It could be 2 years. It really just depends. I had a case that was just like a misdemeanor case. The statute of limitations on it is 2 years, and we didn't have a court date until 18 months down the line. So it can really, take some time, and depending upon the county, depending on the resources, depending on their staffing, there's so many factors.
Yeah, and we'll see how this one plays out. Just a horrific case, to say the least, out of Texas. Bridget Williams, it's always great to have you on Law and Crime, even for tough stories like this. Thanks for talking with us.
Thank you for having me.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.